going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you're having a great day so far. Happy Friday. Happy Black Friday. Happy day after Thanksgiving. Happy middle of a long weekend. Whatever. Just thank you for joining me. I do appreciate it. You guys want to watch some court? I want to watch some court. Let's watch some court. I've got 3 cases to play tonight. We are going to start in Judge Buchanan's courtroom, where we have we got a fun one. Let's just say that we'll stay at fun. Then let's see what do we have. I've got a Judge DeSanto clip and a Judge Gauthier clip. So we're gonna be kind of bouncing everywhere in Michigan. I think that's everywhere. I don't know. Anyways, you guys ready? I'm ready. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right, on the record in state of Michigan versus Ali Copeland, 2500137 FD.
Anna Buckingham for the people.
Dora Khalil on behalf of Mr. Copeland, who is standing to my left.
And you are Ali Copeland.
Yes, Your Honor.
Today is the date for sentencing on this OWI third case. We have received the Department of Corrections report. Have both counsel had a chance to review that?
Yes, Your Honor.
Yes, Your Honor.
I guess we'll start with, are there any corrections to the scoring of the guidelines?
No, Your Honor, not from the people.
No.
So we believe the guidelines are correctly scored at 0 to 16 at this point.
Yes, Your Honor.
Yes, Your Honor.
Are there corrections to the basic information report?
Not from the people.
No.
As to the body of the report, do we have corrections to that?
Not from the people.
No, Your Honor.
Yeah. The bug has passed. It's made me feel a little weird today, but I feel better. I've been able to eat, without running to the bathroom every 5 minutes. So yeah, I'm better today. Tomorrow I think I'll be back to 100% tomorrow. Today was like a 75% day, but that was so much better than yesterday. Thank you so much for asking, Java Puppy.
I noticed a number of sort of confusing parts in the body of the report. So on page 6 under family, it says sentence fragment, both parents in life and close to them both. What is that supposed to say?
Both parents are in his life and he is close with them both. Is how I interpreted that.
Well, it says they're both deceased, so that doesn't make sense.
Oh. Mr. Copeland, you.
Not both of my parents are deceased,
Okay.
mother and father, and I've stated that.
Oh, that's a swing and a miss from the lawyer. Oh, I interpreted it as both parents are in his life. No, they're dead. Yeah, good job. Good job, attorney.
With the
And it says that above it. So this is where I had them correct one other area of it that didn't make any sense, but this spot they didn't correct.
Your Honor, I believe they were talking about growing up co-parenting well. I'd assume they mean
No.
that both parents were.
Striking the sentence fragment. I'm disappointed in the report, to say the least, about the attention to detail as I used to experience in reviewing these reports as a defense attorney. So I just want to make sure that it's accurate, because what counsel may or may not be aware is that this report could follow Mr. Copeland every time he's charged with a felony for eternity. And so if something is incorrect in here, that could be something that affects him 8 years from now, so trying to make sure it's accurate as possible. Did we note any other corrections?
No, Your Honor.
Your Honor.
Do the people have a position on sentence today?
No, Your Honor, we'll defer to the court.
Ms. Cleo?
Yes, Your Honor. Thank you. One moment, my computer is being slow.
Java Puppy. I was actually going to pause it and say, hey, Rob, but it was right after I paused, so
Yes, Your Honor. So,
Anyways, hey,
you
Rob.
know, Mr. Copeland is absolutely fine with the recommended 24 months of probation and adhering to all recommended conditions. The only thing that I would ask is that the recommendation for 30 days jail with his credit for 2 days be limited to serving it on the weekends if possible, so that he doesn't lose the good job that he currently has. In addition to that, Mr. Copeland's biggest concern at the moment is maintaining his sobriety. And after that, it's so important to him that he keeps his employment, so he can continue to provide for himself, his fiance, who's here today, and support, and his children. He does have 12 and 15-year-old boys that he is looking forward to gaining custody of soon, as long as he is successfully on probation. He knows he will be a good role model for them.
Ms. Cleo, why is your client testing positive for alcohol on Tuesday and Friday if he's so concerned about his Friday?
Your Honor, I have not received those alleged violations at this point, and so I wouldn't feel comfortable addressing them until I've been able to review the exact dates, times, and reports.
Well, you're welcome to take these and look at them. One of which I just received this morning. I received them both this morning. One I heard about last week, but I didn't see it this morning. You can step outside and talk to your client about that.
Your Honor, I believe I have spoken to Mr. Copeland about potential violations that could arise, and I believe that these are what he was expecting. And he does work with alcohol-containing substances in his job, and I would defer to him to explain exactly what substances those are.
Okay. So you told me you wanted a chance to review the test. So I offer you an opportunity to review the test, and then you don't want an opportunity to review the test?
Your Honor, I'll take the opportunity. I just wanted to confirm that I believe I have spoken to Mr. Copeland about the potential forthcoming violations, just that we haven't received them yet.
Wait, how does that make sense? Rob, I don't understand. So she's talked to him about the violations, even though she hasn't received them yet. How did she know there were violations then? Maybe he told her? I guess that would make sense. Maybe? Yeah. Baffled here.
Yes, that's why I think she, yes, yes, it's stated.
Your Honor, Mr. Copeland hasn't.
Stated to that JST and called to, I was able about the situation. Yes.
Mr. Copeland is able to explain that he's had conversations with JSG. I'll let him explain those and what exactly the circumstances and environment are of his workplace.
Yeah, I didn't edit out this dead time. Sorry, guys.
Okay.
But thank you, Rob.
Mr. Copeland, what would you like to say to that?
Yes, how you doing this morning?
Fine, thank you.
Okay, I work with acetone, allodyne, and paint thinner, and I forgot all the other stuff. I tried to get the documentation from them at work, but some of the stuff is so confidential because we make the parts for the army tanks and stuff, so they're not allowed to share a lot of the stuff. And I discussed that with them when I was there. So the situation is the stuff that I use, you put the latex gloves and theirs on, because we have to rub the oil and get everything off before we're able to sandblast and use. And it's so strong, we use the respirators to have them on, but it goes through them and stuff. So when I proceeded to do my test, I proceeded and did my test. And when it came back saying retest, I contacted JSG, explaining what was going on with what I work on and what I'm getting is they're waiting on it to tell me to retest again. They told me, okay, retest again. So that happened and I kept retesting and it went through. Now, the other day, rushing to go to work, I messed around and left my, on the table in the house, I left my piece that goes to the breathalyzer. So when it was time for me to proceed to do my breathalyzer that evening, because I'm on afternoon shift now, I have to be at 3:18 till 2 in the morning. So I'm at work and we had the parts we had to do, we had to use the acetone and everything to clean them. And we also have to dip them in the alkaline in the tanks. So these chemicals, even though you have the respirators on, the little filters, we have to change them. But in that process, when it was time for me to do my breathalyzer, I went to my bag to get my machine and my bag, my piece out. It wasn't in there. So I reached out to my fiance and told her I don't have my piece. So I contacted JSG, explaining to them I don't have my breathalyzer piece, and I'm not supposed to blow into this machine without the piece. And I explained to them what all I do at work and what I deal with. And that's when the lady said she was going to contact the main office by email. So I proceeded to blow in the machine just with no piece. I blew it, it told me to retest. I sat down, waited the 15 minutes like it tells me to retest. I blew it again to 15 minutes like it stated me to do. It told me to get it again. I blew it again. And I discussed with my coworkers and everything what I deal with the machine. A couple of guys that work with me, they said, oh man, I had that machine before. I work it. And in the process of me trying to blow it Friday, it told me wait for the blue light to come on like you're supposed to wait. It didn't go through the process to tell me to blow. I contacted JSG, which is a 24-hour line, stated to them what was going on. They told me they'll reach out to the office. Someone will contact me. I got a call Saturday morning, which I had reached out because I couldn't blow that Saturday morning, which I supposed to blow between 6:30. I reached out to them. They told me they'll contact me. Gentleman contacted me back and said he could meet me to JSG to change out the machine because I explained to him what it was doing. So when I took it into him to the place, it showed where you cuts it on, and it says wait for flashing light. As it goes for flashing light, it goes back to saying test not sent. So he looked at that 3 times and then he changed me out and got me a new one. And that's what I have. And I explained to him what all I do at work, what I work with. He said, I know about that plant person. He said, yes, a lot of chemical stuff. It would give you a test positive. So I have my new machine in my bag that he just gave me Saturday, which my fiance took me out to Mason to get. And I explained that to him. And I have his number in my phone, which is the actual, I think he's the manager. He said he doesn't stay far away from there. So he met me at the place to get a new one. And I explained all that to him then, what I've been going through. And he said he did have the calls where I called in to reaching out what was going on with the situation.
You realize you spent your whole time talking about just that and nothing else? You know, I'm here to sentence you for OWI 3rd. Anything else?
Well, Brianna, I'm proud to be sober and doing what I need to do. I continue to go to my meets. I don't have no use for alcohol. I don't have no urge to drink or do nothing. I just been staying focused of going to work, going to my meets. And I even reached out to Brandon, telling him that the stuff I deal with and how it's been stressing me, how I've been getting this test like that. Just being honest with you.
In your honor, I actually did not finish my allocution just because these alerts came up. I just wanted to mention one more thing, which is that Mr. Copeland has been attending AA meetings 2 times per day, which is actually quite impressive given that he gets off of work at 2 a.m. So he's making that early bird meeting in the morning as well as attending in the latter part of the day. Thank you.
Yeah, the dead time is killing me. I just unmuted my mic and started talking to my water glass, because that works, right? If I talk to my water glass, you guys can hear me. Everything okay? Now I'm so weird. But I did pause at the perfect time because I got a super chat. None of your business. Thank you so much for the super chat. Found this thing called Cheshire Card. Ready to give it a try. Let me know if it goes through. I think it did. Thank you so much. None of your business. I appreciate it. And Cheshire. Absolutely. Thank you. You know what's going to happen? I'm going to fast forward it and not be able to get back to the part we need to be. Let's see. Oh, wow. I just jumped a minute ahead and she's still quiet. Yeah. Sorry, guys.
It really just has.
All right, here we go. Sorry about the downtime.
Copeland, it's always a challenge when somebody does not complete sobriety course, when Department of Corrections recommends an additional term of probation. But I also keep in mind the interest in protecting the public from you drunk driving on the streets. You know that you burned your credibility with me a long time ago. So your story about whether or not your scram tether is or your sober link is because you used or not, it really just has no weight with me at this moment. Firstly, you will be serving your 30 days jail at the front end. That's the mandatory minimum for the offense. And I don't see that you were given an opportunity to avoid that with sobriety court. You threw that opportunity away. So you will serve that time.
Your Honor,
Further, Mr. Copeland, are you
Sorry.
serious right now?
I'm sorry.
24 months of probation is recommended by the Department of Corrections. During probation, you must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinks on site, unless your field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of alcohol testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with testing procedures. You must present proper identification at the time of testing. You must comply with the requirements of drug testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with testing procedures. You must present proper identification at the time of testing. You must pay the cost of your substance abuse testing. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by a licensed physician. You must attend AA, NA, CA, or at the frequency required by the field agent. You must complete outpatient or residential substance abuse treatment when you're referred by the field agent. You must complete substance abuse assessment when you're referred by the field agent. You must complete cognitive behavioral program. You must waive confidentiality and allow any treatment program that you're required to attend to disclose information to your field agent. You must comply with the Michigan Department of Corrections electronic monitoring program as directed by the field agent. You must perform 480 hours community service as directed by the field agent. You must obey all court orders. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have verbal, written, electronic, or physical contact with anyone who is housed within a Michigan Department of Corrections facility without permission of the field agent. You must not have verbal, written, electronic, or physical contact with anyone you know to be engaged in any behavior that constitutes a violation of any criminal law of any unit of government. You must not use any object as a weapon. You must not own, use, or have under your control or area of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must contact a supervising field agent no later than the first business day following your placement on probation or release from jail. You must comply with written or verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without the need of a warrant, and if the field agent has reasonable cause to believe that you have items which will violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must not drive a motor vehicle unless you first obtain written permission from the field agent. You must not drive a motor vehicle. Have it separately broken down. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week unless engaged in an alternative program approved by the field agent. You must provide ongoing verification of employment or alternative program to your field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from your field agent. You must serve jail time as follows: 30 days jail. You must pay restitution in the amount of $19,399.47 as broken down between the two listed victims. You must execute a wage assignment to pay restitution if you're employed and miss 2 regularly scheduled payments. You must pay a crime victims assessment amount of $130. You must pay $68 state costs as ordered by the court. You may not engage in recreational use of marijuana or use medical marijuana in violation of the Michigan Medical Marijuana Act. You must complete 90 days of MDOC scram tether. I've also ordered a $500 fine and $892.30 cost recovery for the Lansing Police Department, as that was previously part of your sentence. I put intensive outpatient or residential at the discretion of your probation agent. Upon review of your testing history, your agent may or may not want you to go to residential treatment at this point based on the number of positive tests you've had. If you'd like to appeal my sentence and you need a public defender to assist you, you need to make your application within 14 days. Anything additional for this sentence today?
People. No, Your Honor.
All right, Mr. Copeland, you're going into custody now.
Girl, get up, please keep my job. Do weekends,
Sir.
please.
Copeland, we tried specialty court. This is what happens when you don't comply with special court.
Can I, 1 second, can I give my wallet and stuff to my fiance so she can take it, can I give her my keys and stuff, the stuff?
That's fine.
Can I give her my stuff?
Take it out of your pocket and set it on the table.
That's what I'm just asking. That's what
Take it out of your
I'm
pocket and set it on the table.
I mean, can you call my job and let me know about it?
Behind your back.
I ain't trying to move, man. I ain't trying to move.
All right. That was a good way to start tonight, right? That one was fun. Sparkle Poots, thank you so much for the super chat. Celebrating Colin's fire editing skills. Yeah, they were on fire for that one. I'm sorry for the downtime. It's dead air. I don't know why I say downtime. It's dead air. Are they interchangeable? I don't know. Anyways, we're moving on. We've got a Judge Gauthier case. Gauthier. Yeah, you know what? I'm not gonna lie. I really just wanted to play a Judge Gauthier case, so I found one, and we're going. Let's go.
All right, so we're back on the record, and then next we're calling the cases of People v. Robert Willnau. It's files 25-7027 and 7028 FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
No, not Giller for Mr. Willnau, who appears in person in custody to my right.
All right, we're here for sentencing in 7027 on possession of methamphetamine habitual second, 15-year statutory max. guidelines at 10 to 28 months. And 7028, delivery of LSD, habitual second, statutory max 10.5 years, with the guidelines range of 9 to 28 months. Have you had a chance to review the report and recommendations with your clients?
Have, Your Honor, finding no errors or omissions.
Okay, and any scoring challenges?
No.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, and I have received a letter of support submitted by Ms. Fulp for Mr. Willnau. Give me a chance to review that here. Thank you, Mr. Nightingale. I've had a chance to review that letter. Go ahead with any allocution on behalf of your client.
Thank you, Your Honor. So on behalf of Mr. Willnau here, he is comes before the court, 53 years of age. He does have 5 prior felonies, 13 misdemeanors. He has a binding sentence agreement here for a county cap as to both these cases. Obviously, the PSI recommendation does not comport with that agreement. We think that the court should follow the agreement of the parties rather than the recommendation contained within the PSI for a few different reasons. First is, obviously that Mr. Willnau has accepted responsibility for these cases, and that should be considered a mitigator in some respects. Further, Judge, Mr. Willnau has got some pretty significant health issues. I think these are outlined fairly well in the PSI, but in addition, in Mr. Willnau's sister's letter that the court has now reviewed, he suffers with some pretty intense diabetes and has done for a long period. It's my understanding that within the jail, he's having a real problem getting his sugar under control. It's not exactly the best environment for somebody who's dealing with those kinds of major health issues, not just for him, but also for the jailers. Frankly, that's potentially a lot of liability and a lot of maintenance. That kind of diagnosis requires constant surveillance, and they have better things to be doing, I think, at the end of the day, although they are constitutionally obligated to make sure that Mr. Willnau is alive and well inside the jail. And so these two things are
They'll say it in a second. They'll say it in a second. I'm trying not to spoil too much of it. Real quick, Alan, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you so much, Alan.
in conflict. We're asking the court to abide by the agreement and to sentence him to a limited county sanction. He has done some prison time. It's been a long time. His history, although fairly large, is also quite old. I mean, his first conviction, at least in the PSI, is from 1989. That was for a misdemeanor larceny that he pled to. He's done treatment at least once before as part of a parole sentence that he received in the late 2017 matter, I think. He did Harbor Hall as a part of that sentence. As a part of this case, while he was out on bond, he did go to Bear River for a little while. He was unfortunately not successful at Bear River because of his health issues. I don't think it was a lack of commitment on his part. He just had such a hard time dealing with his diabetes while he was there that it made it pretty difficult for him to even attend classes. And so, although he tried to get the most out of it as he could, he was just very sick while he was there and ended up being discharged for those reasons. He did also apply for recovery court here, was told that he's not a high enough need / not a high enough risk to reoffend. And so that, I think that cuts both ways, right? Is that he doesn't get the program that he may so desperately need. And also, then the court then should consider him a low risk to reoffend, right? I mean, if he's not in that category, he's in the other probably. And so I would say based on his age, the fact that he got busted for this basically twice. One of these was essentially just a residue case of, he's got the first case and then he's found in a house with some residue in front of him. The court should consider these to be not the most serious charge as far as the continuum of the charges are concerned, right? I mean, I think as the court noted earlier, it's, this could have been a large quantity of methamphetamine, and it still would have been the same charge, the same penalty. And so it wasn't, right? This is sort of a personal use thing. Although he's got the dealing ahead of it, I think Mr. Willnau's contention that he was sort of engaging in this type of behavior as a way to both account for his personal use and to try to take care of his fiance that was dying at the time. He does have some periods of extended sobriety as far as, heavy drugs and narcotics are concerned. It does seem in the PSI that Mr. Willnau has indicated that he doesn't really indicate or intend to cease his use of marijuana or alcohol. He is 53 years old. He's been doing that kind of stuff for a long time. I don't think the alcohol use is helpful for his diabetes, that's for sure. And I think that he's starting to recognize that. Certainly, I don't think Mr. Willnau would have had any bond issues had he been able to just quit drinking. That would have made a much easier argument for us going forward right now, and probably could have let us resolve this case a little quicker. But nonetheless, he did have some issues. What I think is most notable for him is that he has recognized those issues since our last court hearing when we tendered our plea. The court did continue his bond after he tendered that guilty plea as to both cases. And then Mr. Willnau out in the hallway basically demanded that the court revoke his bond. He just was not confident that he could stay on the straight and narrow here while his sentencing hearing was pending. And so I certainly commend him for that accountability and for that sort of self-knowledge. Not a lot of my clients have that kind of insight to know themselves enough to say, I can't do this and I need to not be out right now while I have this really good deal the prosecutor's giving me. And so we're asking the court recognize that as well. I think the court has done that in some respects already, but just want to remind the court that did occur, that Mr. Willnau has taken great accountability here. He's willing to do anything the court orders him to do, but mostly he wants to be out to support his family. As the letter that his sister wrote indicates, he's got some family members out there that really need his assistance. He could do some jobs out in the community, although he's on disability. And so I think more than anything, it's more important for his family members that he be out and that he be able to take care of his other family members that have these other significant health issues, not diabetes related. So, Judge, all that being said, Mr. Willnau is ready and willing to do anything the court wants him to do, up to including completing treatment again. I think that if the court decided to put him on probation, he would, of course, cease his use of alcohol and marijuana as a part of that probation sentence, because he would have to. And so, but if the court does not want to put him on probation, if the court thinks that he's not a good candidate, we would just ask for a county sanction, no additional probation, limited fines and costs. And that's it. Thank you.
Thank you, Mr. Nightingale. Mr. Willnau, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me or no?
No.
That's fine. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. What led us here is the defendant had delivered LSD with the help of a co-defendant. When he was arrested on that, he was found with methamphetamine. To his credit, he was honest and cooperative with the officers. He admitted that it was his and he liked to mix it with his marijuana. The defendant is 53 years old. He has 5 felonies and 13 misdemeanors. He admits in his PSI he's had daily use of methamphetamine beginning in 2024. That he's not likely to abstain from alcohol and marijuana, no desire to. I would agree, Mr. Nightingale, he was honest and turned himself in. We were last in court knowing he wouldn't be able to abstain from alcohol, so probation doesn't make sense at this point. The plea agreement is to a county jail cap with $100 restitution. I would ask the court to order 10 months jail, which is still within the Michigan sentencing guidelines. Thank you.
All right, Mr. Willnau, if you please stand for the court sentence. Well, Mr. Willnau, you're 53 years of age. You have 5 prior felonies, but I note your last felony was well over 15 years ago. Had some misdemeanors in that time frame. And, you know yourself well enough that you knew that you weren't going to comply between the plea and the sentencing. In fact, you had some difficulties back in the jail because of how much you'd indulged and just stopped testing prior to. So I hope you're past that difficulty now. But I think, that I think explains the recommendations of the Department of Corrections for a prison commitment, because I think there might be some frustration that I frankly share that, you don't seem interested in change. That's a good reason not to put you on probation. And so I'm not going to do that. And, it's been over 20 years since you had a drunk driving. So, I mean, alcohol and marijuana are both legal and you're not on probation. You can use those as much as you want and kill yourself with your diabetes if you want, as long as you don't drive. But you're not here because of alcohol or marijuana. You're here because you were selling LSD. So you got to know, you start getting involved in that, you're going to be back in front of a judge. So if you want to get as drunk or stoned as you want and not go in front of a judge, you do you and do the legal stuff. But you start getting into selling drugs in our community, and with your history, delivery of LSD is not the class of that sentence is not as much as, like, if you'd been caught selling methamphetamine, you'd be guaranteed prison sentence. But even with the LSD, it's a guidelines that would allow for prison. So, when was the last time you did prison? How old were you when you did prison last time?
2017.
Okay. So like almost 10 years. Well, okay, 8 years ago. Okay. So you were in your 40s. Well,
Yeah.
Life, I'm sure if you've noticed, in your 50s is a little tougher than when it's in your 40s.
Yes.
And prison in your 50s is probably going to be tougher than prison in your 40s. So I don't know. I don't know what to tell you, Mr. Willnau, other than what you ought to do to avoid going to prison. I think on the balance, doesn't make any sense to place you on probation, but I do agree with your attorney and the prosecutor that with this plea agreement, that there's nothing about the facts in this case that really cry out for a prison commitment. So I'm gonna go ahead and stay within those bounds. So, Mr. Willnau, in file 7027, the possession case, I'm going to order that you actually in the pre-sentence report, I think the restitution is tagged in that case, but I think it's supposed to be in the 7028. So in 7027, I'm going to assess $68 in state cost, $130 crime victims assessment, and $350 in court costs, and order that you serve 10 months in the Sheboygan County Jail with credit for 51 days previously served. That's within the advisory guidelines and the plea agreement. In 7028, I'm going to order that you pay a $68 state cost, $130 crime victims assessment, and $100 in restitution. And that in that file, you serve 10 months in the Sheboygan County Jail with credit for 74 days previously served. And those sentences will run concurrent with each other. If you wanted to appeal, you may do so by filing an application to the Court of Appeals. If you wanted a lawyer, I would give you one, but you'd have to make that request within 6 months. So we're going to hand you a piece of paper explaining those appeal rights in both files and ask you to initial one copy for us and the other ones for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
Is there any way I can do, did you serve or share anything while I'm in the jail?
Yeah, I gave some thought to that with the length of sentence. I a lot of times approve that, but I think given Mr. Willnau's, I guess, demonstrated lack of, I guess, hope for real change here, I'm not going to approve any programming. So you'll get your good time credits, but I'm not going to approve any additional credits. All right, so good luck, Mr. Boone.
All right. That was Judge Gauthier. Yep. Like I said, I wanted the case, so I found one to put it in. All right, moving on. We're going to DeSanto. Judge DeSanto is the last one. Yeah, I mean, that's really all I have. Let's go.
And we are on the record in the matter of the City of Wyandotte versus Nicole Weems, 251269.
Morning, Your Honor.
Good morning.
Your Honor, John Goldblatt, P 30758 on behalf of Ms. Weems. Ms. Weems, please put your name on the record.
Okay, Ms. Weems, you're on probation with this court.
Yes.
And yet, here you are. Counsel, as to the arraignment.
Your Honor, as to the arraignment, she stand mute to the charge, waiver form reading of those charges, asked that a plea of not guilty be entered on her behalf.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial.
As to the pretrial, Your Honor, I've had an opportunity to discuss this matter with Ms. Weems. I've also discussed with her the fact that she is on probation and that this would have an adverse effect, entering into some sort of plea with respect to that. But knowing all of that, she wishes to avail herself of the plea that's been reached. My understanding that he will, in return for a plea of guilty to operating while impaired, the people would move to dismiss the original charge of operating while intoxicated by BAC. Explain to her constitutional rights and explain to her the rights that she would be waiving by entering into this plea agreement. She wishes to avail herself of this opportunity, and she does understand those constitutional rights. Is that correct, Ms. Weems?
Yes.
And there are no immigration issues.
Please raise your right hand, ma'am. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
And you've gone over your advice of rights with your attorney, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone, and you understand the rights that you've gone over with your attorney, correct?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
You do understand, ma'am, that this is likely going to trigger a probation violation, correct?
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
I can't hear you.
Yes, I'm sorry.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues? I'm sorry?
No.
Counsel, if you can please pardon your client.
Ms. Weems, on August 25th of 2025, you were operating a motor vehicle in the city of Wyandotte.
Yes.
And at there come a point in time where you came into contact with some Wyandotte police officers.
Yes.
And prior to coming into contact with those Wyandotte police officers, were you consuming alcohol?
Yes.
And,
Ma'am, you need to keep your volume up, okay, please?
and what were you drinking?
I had a bit of bourbon.
You had a bit of bourbon.
Yes.
Would you state you had quite a bit of bourbon?
Yeah.
Okay. And, when you were, seen by the police officers, they gave you some certain field sobriety tests, is that correct?
Yes.
And, eventually you were detained and you took a PPT as well as a breathalyzer test, is that correct?
Yes.
And the results of that breathalyzer test were 0.1.
0.184.
And 184, is that correct?
Yes.
Okay, the other one too. Thank you, Your Honor. Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea, your very generous plea that you were provided, ma'am, and dismiss the original charge per the plea agreement as to bond counsel.
As to bond, Your Honor, Ms. Weems has complied. She's appeared here today. She's gainfully employed. As the court is well aware, she is on probation to this court. This was obviously when we spoke to her. When I spoke to her, I informed her that this would be a violation of that probation. She understood that. She told me, when I questioned her, what was going through your mind, she said it was just a real bad day and that made it worse. So I'm just indicating that to the court. I'm asking that she's accepted responsibility for this incident as well as a probation violation by entering into this plea at this point in time. We're asking for a personal bond as she gets ready to go for sentencing.
So, ma'am, you had a lot of real bad days, it appears, in this court, because your matters date back all the way to 2022. In 23, failed to display a license, allowing an unlicensed driver to drive. That was as a result of a driving while license suspended. Another driving while license suspended, plate violation, possession of paraphernalia, which is what you're currently on probation for, and now you have a high BAC.
Okay.
You're not allowed to drink alcohol on probation anyway, ma'am.
Okay.
Yet you did it anyway. Well, the verdict test right now, what's in your system? When's the last time you consumed any alcohol?
That night.
Where do you work?
Right now, I just got a new job at, it's called Bank Who's Life. It's a life insurance agency.
Well, given the fact that you're on probation for possession of paraphernalia, and you've completely disregarded the conditions and orders of this court for probation purposes, the court has concerns that you're going to disregard its orders of bond. To ensure that you're not going to do that, the court's going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed, which you're already not allowed to do because you're on probation. And then you are not to be released without an alcohol tethered through the Wayne County Jail.
Your Honor, can she be able to post it, make arrangements, rather than going to Wayne County Jail to obtain the tether
Yeah.
here, if that can be posted? Instead of through the Wayne County Jail, the tether.
There's no talking in court. If you want to have a conversation, go out into the lobby, sir. No, your client's being taken into custody. She's not going to be released until she has the Wayne County Jail alcohol tether.
Thank you.
So you're going through this door today, ma'am. You want to have a conversation with your work that you won't be there.
When she's released, you then, what's that, too? Wait. It's time to speak today.
Okay, ma'am, you can step out into the lobby because you and your person next to you continue to talk. That's why you're out in the lobby.
You know, I didn't really think I was streaming tonight either. I don't know. In my brain, I think today's Saturday. So I was like, oh yeah, it's my night off. No, it's not. Yeah, it's not. So yeah, hi, I'm here.
Counsel, I indicated that your client's taking the ride down to Wayne County Jail to get the tether.
I understand, John.
Yes.
And then when she's released on the tether, she will then have to appear for.
Oh, for a PSI, yes.
What I was.
I'm sorry, I didn't understand
what you were saying about going to Wayne County. Yeah.
Yes,
It was just confirming what she's to do once she.
yes, yes.
Okay, thank you.
All right, thank you. Have a good day.
Yeah, that's it. I did not pause it enough during that. I did not pause it enough at all. That's not good. Only 3 minutes of a 50-minute video I was talking. Yeah, so I let that one run. I guess that's just how tonight went. But thank you guys so much for watching. I do appreciate it. And yeah, I don't really have anything else to say. Tomorrow night's date night, so I'm going to be off tomorrow night. So I hope I'll see you guys back on Sunday. Have a great rest of your weekend. I hope your football team wins. Mine won yesterday. Burrow's back. Whoop, whoop. Yeah. A little bit too late, but maybe. There's still a chance. We're not out of it yet, but we kind of are. All right, you guys are awesome. Thank you so much. It is early. I don't think anyone's streaming yet because it's not 9 o'clock. You know what? I'm just gonna wish you guys a good night. I'm not gonna look for someone to raid. You guys have a great rest of your night. I appreciate it. Thank you for the super chats, the gifted memberships, mods. As always, you are awesome. Thank you so much for your hard work. And yeah, I'll see you guys Sunday night. Until next time, bye.
We're on the record in the matter of the city.